Current case, current intent. Part filed by the judges. They prep for oral argument.
Good evening, everyone. Welcome to everyone here in the beautiful Carter and Keep Courthouse of the Southern District of California in downtown San Diego, and everyone who is joining us online across the circuit, and I believe even some people on the other coast. Thank you for joining us. My name is Johanna Hartwig, and I am the Executive Director of the Ninth Judicial Circuit Historical Society. And we are so pleased to be putting on this fascinating panel tonight, tackling the Bruen Bear, and to be co-sponsoring this with the Federal Bar Association of San Diego. For those of you who do not know, the Historical Society has been around for about 40 years now, and we cover the entire Ninth Circuit. Our mission is to illuminate the engaging and fascinating legal history of the Ninth Circuit, as well as to amplify the importance of an independent judiciary. And we have three things that we do to pursue our mission. First, we do really interesting panels like the one that you are about to see here. To give you some examples of other recent panels, we just had one on gambling law in Las Vegas last week and new developments in gambling law. And we also did a very interesting panel a month ago in Sacramento that was talking about the stories of Japanese American internees who resisted the loyalty oath and a civil rights attorney who represented them. In addition to the panels, we have a law journal called Western Legal History, and we tackle issues that are of import both historically in the circuit as well as currently. So our last double issue was indeed on gaming law. The one before that was on water law, and our upcoming issue is going to tackle some important due process cases in the public school setting. So we invite you to come to our website, njchs.org, to check those out. And the final thing that we do at the Society is we capture oral histories of judges in the circuit and prominent attorneys to be able to share their extraordinary stories. So I want to give a very warm welcome to our panelists tonight, who will be introduced by our able moderator, Judge Larry Bruen, who recently retired from this court here, and who will be introduced by the FBA president in a minute here. But I also want to take a second to really very sincerely thank the Southern District of California, Chief Judge Sabraw, his colleagues on the bench who are attending tonight, Clerk of Court John Morrill, who have all been extraordinarily supportive of our bringing this panel here today. It's been a while since we have been down here in San Diego. I spent 2 wonderful years clerking for Judge Margaret McEwen on the Ninth Circuit down here. I'm so pleased to be back, and I look forward to our being able to have many events here in the future. Now I would like to turn it over to the current president of the local chapter of the Federal Bar Association, Blake Curry.
Well, thanks so much. And on behalf of the San Diego FBA, we're pleased to co-sponsor this event tonight, but let's get to it. So I have the privilege of introducing our moderator, which is the Honorable Judge Larry A. Burns, who's sitting on the far end there looking sharp. So Judge Burns, earlier this year, he joined Judicate West as a neutral after 27 years of distinguished service here in the United States District Court for the Southern District of California. He served as a magistrate judge, then a district judge, and ultimately as our chief district judge from 2019 to 2021. And those were some uneventful years, huh, Judge Burns? As a trial judge, Judge Burns presided over 300 federal jury trials, so he's no stranger to both criminal and civil rights cases involving constitutional issues. And then before becoming a judge, as an advocate, Judge Burns not only tried 150 cases to verdict, but he also argued 40 cases before the Ninth Circuit. So welcome, Judge Burns. I'm going to turn it over to you, and thank you for moderating our program tonight.
Thank you. I'm going to make an assumption that most of you are here because you have interest in this topic, interest in the Second Amendment and the application of the rules that apply to it. Let me give you a very brief overview of what you're going to hear about tonight. In District of Columbia versus Heller, decided in 2008, the Supreme Court announced that the Second Amendment protects an individual right to keep and bear arms for private purposes, such as self-defense. 2 years later, in McDonald versus Chicago, the court ruled that the right also applied as against the states. However, in both of the cases, the Supreme Court hastened to emphasize that the right to keep and bear arms, like all constitutional rights, is subject to various forms of regulation. What was left to be decided was how courts should go about the complicated task of holding the balance true between this important constitutional right and then the many legitimate forms of gun regulation that are with us today. Our objective tonight in this presentation is to examine and to explain current Second Amendment jurisprudence. It is, to be sure, a complicated subject, one that lawyers and judges often find very, very confounding. Our esteemed panel members, all of whom are experts on the Second Amendment, as you will hear in just a minute when I tell you about them and give you their biography, will not attempt to relitigate cases that have been decided, nor is the purpose of the panel to be predictive as to where we're going or what's going to happen. Instead, the discussion tonight that we'll have with you is going to focus on how we, as lawyers and judges, should approach the complicated question raised by legal challenges to modern-day gun restrictions and regulations. Stated more colloquially, how should we think about Bruen? I want to introduce our panelists tonight. To my immediate right is Professor Adam Winkler. Professor Winkler received his Bachelor of Science degree in Foreign Service from the Edmund A. Walsh School of Foreign Service at Georgetown and his Juris Doctorate from the New York University School of Law. He also has a master's degree in political science from UCLA. After law school, he served as a law clerk to Judge David Thompson of the U.S. Court of Appeals for the Ninth Circuit from 95 to 96, and then was selected as the John M. Olin Research Fellow at the University of Southern California, USC, from 2000 to 2002. He joined the faculty of UCLA in 2002, where he is now the Connell Professor of Law. He's a specialist in American constitutional law. He teaches courses on that subject, as well as a really interesting course that I looked up, Supreme Court Simulation. It's a course designed to enhance the presentation and writing skills of students by having them make oral arguments and write opinions as the Supreme Court might do so, using current cases before the court. He also teaches professional responsibility and gun rights and regulation. Professor Winkler has written extensively on legal history topics such as the origins of campaign finance law, the women's suffrage movement, and the regulation of political parties. His writing on the right to bear arms, which recognizes both the individual right I mentioned to possess firearms and the legitimacy of effective gun control, has been cited by the U.S. Supreme Court and numerous judicial opinions of the lower court. Indeed, he's one of the 20 most cited professors in judicial opinions today. He's the author of We the Corporations, and We the Corporation, How American Businesses Won Their Civil Rights, and a second book, more pertinent to our subject tonight, Gunfight, The Battle Over the Right to Bear Arms in America. Along with historian Leonard Levy and fellow UCLA law professor Kenneth Karst, he edits the 6-volume Encyclopedia of the American Constitution. He's won many awards for his scholarship and his writing, including book awards, awards for teaching. He's been recognized by his alma mater, his law school alma mater, NYU, for a law teaching award, and he currently serves on the board of the Brennan Center for Justice. Before joining the UCLA faculty, he practiced law in Los Angeles. He was on a litigation team that represented the late Michael Jackson in a highly publicized child molest case. And finally, a fun fact about Professor Winkler: he's the son of Academy Award-winning filmmaker Irwin Winkler, and as a child, he had small acting parts in movies, including Martin Scorsese's New York, New York. So we welcome you. Next is William Taylor. He is the co-chair of Every Town Center for Gun Safety. This is the largest violence prevention organization in America. He serves as deputy director of Second Amendment litigation for that organization. In these roles, he supports state attorneys general and city attorneys in Second Amendment cases. He helps manage every town's amicus practice. He represents municipalities defending their gun laws in court, and he speaks publicly at law schools and other settings about the Second Amendment and the future of gun litigation. Bill Taylor received his bachelor's degree in public policy from Duke University, where he graduated Phi Beta Kappa. He then attended and graduated from the Harvard Law School, where he served as editor and book review chair of the Harvard Law Review, also served on the Harvard Journal of Legislation. After law school, he also served as a law clerk for the Ninth Circuit, working for Judge Kim Wardlaw. Before joining Everytown, Bill served for more than 5 years as an assistant attorney general in the litigation bureau of the New York Attorney General's office, where he represented the state and its agencies and officers in a wide variety of civil actions, particularly focusing on the Second Amendment. He was lead counsel for the state of New York in numerous Second Amendment and other gun cases, including New York State Rifle and Pistol Association versus Cuomo, in which the district court upheld New York's restrictions on assault weapons, large capacity magazines against a Second Amendment challenge, a decision that was later affirmed on appeal. In recognition of his work on gun litigation, Bill received the 2016 Louis Lefkowitz Memorial Award, Outstanding Performance as a Deputy Attorney General. He previously worked for over a decade as a litigator at the noted New York firm Paul Weiss, Rifkin, Wharton, and Garrison. He had a broad general civil litigation practice across a variety of matters there. He's a member of many bars, both district and circuit courts, federal district court, federal circuit courts, as well as a member of the New York bar. He's been a featured speaker on the Second Amendment and gun violence at numerous symposiums and seminars, including conferences hosted by the University of Chicago Law School, the Columbia School of Law, and the American Constitution Society. He's litigated and argued many cases involving challenges to gun restrictions in both state and federal courts of appeal. He's also co-authored numerous amicus briefs submitted to the United States Supreme Court on that subject. He's considered an expert on the history and evolution of the Second Amendment. Finally, third to my left is Stephen Hallbrook. When I go over this, you're gonna wonder, as I did, how he has time to get anything else done. He's been practicing civil litigation and criminal defense at his own firm since 1978. He's a member of the Virginia Bar and the bars of 10 different federal courts and the bar of every circuit court, federal circuit court in the United States. And then the cherry on the sundae is he's a member of the Supreme Court Bar. He's widely regarded as an expert on the Second Amendment. He's argued 3 cases involving firearms and firearm restrictions before the U.S. Supreme Court. These include Castillo versus the United States, Prince versus the United States, and U.S. versus Thompson Center Arms Company. Let me hasten to add that he prevailed in all 3 of the cases that he argued. He's been the co-author of briefs submitted to the U.S. Supreme Court, including the cases that we're going to talk about tonight, Heller, Bruen, and Rahimi. He got his bachelor's degree from Florida State University, followed up with a PhD from Florida State in 1972, and then his JD from the Georgetown University in 1978. He's been a professor at the college and law school levels. He's assistant professor of philosophy at George Mason. He served as a professor of philosophy at Howard University and also the Tuskegee Institute. And this is the part that confounded me about how he has time to do anything. He's authored 11 books, including one of the leading books on firearm and firearm regulation called the Firearms Desk Book. If you look him up, you'll see a long list of credits, numerous scholarly articles, op-eds, short articles in leading legal periodicals, and on the internet, including sites such as the Volk Conspiracy. As I said, as I was flipping through this and trying to distill it down to some manageable form, it went on for 11 pages. He's writing on lots of different subjects, but mostly the Second Amendment. So please welcome Stephen Hallbrook tonight. All right, let's get started. The first question I have is for Professor Winkler. It's commonly estimated in the United States that there are more than 20,000 gun laws on the books. These would include local, state, and federal restrictions on firearms, regulations on firearms. Historically, legal challenges to these laws were evaluated according to a two-step test that considered public interests such as reducing gun violence. Bruen changed the test that judges have to use. It has emphasized the text of the Second Amendment and the history of gun regulation. Can you briefly trace for us the rationale for this change? In other words, how do we get to where we are today? How does the Second Amendment's textual inquiry work? And what questions are addressed at in this analysis?
Well, great. Thank you very much. Lovely introduction, and thanks to the organizers for having us, for our co-sponsor as well. It's really a pleasure to be here, and of course, to all of you for showing up, because if we're here and you're not, it's not such a great event. So thank you very much. Heller decided in 2008, avoided one of the big questions. It answered the question about whether there was an individual right to bear arms protected by the text of the Second Amendment that had been in some dispute, in some debate. But the next question that is necessary to ask with any constitutional right is, okay, well, what standard of review is to be applied to cases challenging laws under that amendment? That's really where the rubber hits the road in constitutional analysis. You could say a right exists, but the question is, when can government burden that right? And what tests will courts apply to determine whether that burden is constitutionally permissible or not? And the Heller case, even though there's plenty of briefing in the Heller case on the standard of review, the court said, we're not going to determine what standard of review. And the court rejected the idea that rational basis review would apply, rejected what Justice Breyer suggested in dissent, a kind of interest balancing approach that looked a little bit like a kind of intermediate scrutiny. And then a funny thing happened in the years after Heller. The Supreme Court sort of stayed on the sidelines. They had the McDonald case in 2010 that extended the Second Amendment to the states through incorporation, but the court didn't step back in to provide any more guidance as to what standard of review would apply. And in the decade after the Heller case, the circuit courts sort of reached a kind of consensus, a rough consensus around a kind of intermediate scrutiny, that two-step approach that you mentioned earlier. Courts applied this kind of intermediate scrutiny, and it seemed very much at odds with the language of the Heller case. Bruen decided in 2022, came in, and the court not only struck down the New York restrictions on concealed carry permitting that were involved in that case, but the court answered the question that Heller did not, which is, how should courts go about applying the Second Amendment when other gun laws are challenged on the basis of violating it? So, what the court settled on was this text, history, and tradition approach. And the court said that the first question you're going to ask is the underlying conduct that's regulated by the statute covered by the text of the Second Amendment? If it is covered by the text of the Second Amendment, then the underlying activity is protected. And then the question is, does the government have the authority to regulate in that space? And the court said the way we look at that is, instead of applying some tiered means and scrutiny, as the lower courts had done, and as we often do in constitutional law, the court said instead we're going to look to the history and tradition of regulation. And if there is a long history and tradition of regulating this activity, then that's pretty good indication that that activity is not protected by the amendment, that the original understanding of that amendment was that it permitted government to regulate in such and such a way. And if there's no history and tradition of regulation of that particular conduct, that's pretty good indication, Bruen says, that the underlying conduct is protected and the government's regulation goes too far. And I think the way to understand the text, history, and tradition test is it is a standard of review, just like a tiered scrutiny standard of review, but operates with its own rules and looking at your own the factors that are laid out in the text or in the history and tradition of regulation in this space. But it is kind of like a standard of review, and it's going to suffer from some of the same problems of standards of review. I think the reason why the court adopted it was because we've seen the emergence of a real strong cadre of originalist justices on the Supreme Court. And the originalist justices, especially Justice Kavanaugh and his Rahimi concurrence, have made clear that they think that the sort of traditional tiered means-end scrutiny, strict scrutiny, intermediate scrutiny, rational basis review, is wholly judge-made and allows judges to enact their policy preferences, as Kavanaugh said in his Rahimi concurrence. Judges will, if they like the law and think it's a good law, uphold it. And if they don't think it's a good law, they'll strike it down under tiered means-end scrutiny. The idea is for the originalists is like, no, we need to turn to history. We need to understand the original public meaning of this constitutional provision. And the way to do that is to look at the text first and foremost. If it answers the question, it's settled. If the text is ambiguous, as most constitutional text is, well, then we have to look at what did the people understand that text to mean. And the court says one of the best ways to do that is to look at how we, the people, regulated that activity back in the time of the adoption of the Second Amendment in the 18th century. And then the court in Bruen says we'll look all the way up until basically the end of the end of the 1800s, the end of the 19th century, because that tells us the public meaning of the 14th Amendment, which incorporated the Second Amendment to apply to the states. So I think it's really grounded in an originalist approach to judicial review that rejects this means-end scrutiny and is seeking another way to go about thinking about how do you apply constitutional rights when there's going to be ambiguity and we're not going to have evidence from the founding era that's clear and unambiguous about whether they thought background checks were permissible when they had no conception of background checks.
So you mentioned that one of the problems the Supreme Court found was that the means-end approach allowed judges to express their own policy preferences. Did that come out in your review of the 1,000 cases that were decided between Heller and Bruen? Did it emerged that there were policy preferences that were being favored, or that some circuits, for example, didn't favor them, others did? Can you speak to that?
Yeah, I mean, I think that there is no doubt that if judges are asked to figure out what's a compelling governmental interest or an important governmental interest, and whether a law is substantially furthering that interest, it's pretty open-ended, and you're going to get judges, and the perspective that judges have are going to influence the outcome of those cases. And that's clearly one of the motives for the text, history, and tradition approach that this, at least Justice Kavanaugh says, and just in his Rahimi concurrence, Justice Scalia said it in Heller in his majority opinion, Justice Thomas said it in his Bruen opinion, that they think that the text, history, and tradition approach will better avoid that kind of judicial subjectivity or discretion. I consider myself pretty skeptical of that. I think you can't take the judging out of judging like that it's going to always be open. And I think there is actually some evidence, at least so far, and it's still pretty early, to suggest that actually the text, history, and tradition test may be more open-ended in some ways, although the courts are more directed in terms of what they look at. One way to think about whether subjectivity is influencing the courts is to say, well, what are the outcomes that we're getting from the courts? And under the intermediate scrutiny test, under the circuit courts, there was actually pretty consistent results, right? The courts applying that test tended to reach the same result. Now, that was a result that many of the justices didn't like and thought that was undervaluing the Second Amendment. But under the intermediate scrutiny, you had a lot of consistency in the outcomes at the circuit court level. Since Bruen, we've seen a lot less consistency, that courts applying the text, history, and tradition test have split on things like ghost guns, on firearms with obliterated serial numbers, on age restrictions on guns, on sensitive places with guns. And so, if at least so far, if we just look at the data and on outcomes, it looks like there's a little bit more chaos. And there was one study that of the first year Bruen cases that suggested that found a statistically significant correlation between the party of the appointing president of the judge and the outcome of the case, which was not there under the intermediate scrutiny years under the Heller case. So I'm not sure, again, and I don't say that as a criticism of text history and tradition. I think courts are getting used to applying it. It's a new kind of test, and I think it's going to be more popular in more areas of constitutional law, not just in the Second Amendment. And the courts might not really know how to do it yet, and they're still trying to figure it out. And at least so far, it doesn't seem to have limited judicial discretion very much.
So Steve, even before Heller, there were legal challenges to gun cases that were brought in the federal courts. In fact, when looking at your resume, you argued some of those cases involving gun regulations going all the way back into the early 90s. Can you talk a little bit about your strategy in arguing the gun cases before Heller came along?
Certainly, Judge Burns. Look, this is a real pleasure to be here. When I got an email that there's a Ninth Circuit Historical Society and I'm being invited to speak to them, I'm thinking this is a real walk down memory lane for me. If you go back, turn the clock back a little bit, it used to be handguns bad, long guns good. Rifles and shotguns are good, but not handguns. And California in 1989 became the first state nationwide in our history to ban a number of semi-automatic rifles. And I was involved in litigation of that. It was called Fresno Rifle and Pistol Association versus Van de Kamp. The bans were that in the initial stage, it was a long list of rifles like Colt AR-15 and some others. And they were labeled as assault weapons, which is a term, it's really a political term. They could have called them murder weapons, but they wouldn't really be murder weapons. And I mean, traditionally, the way we think about words, if you assault somebody or you murder somebody, those are assault or murder weapons. But be that as it may, what's striking is the Ninth Circuit had played no role in any Second Amendment case up to this point, and it still didn't in this case. Our complaint was dismissed at by the district court, but then we went to the Ninth Circuit, and the Ninth Circuit avoided the Second Amendment issue because first it had to be determined whether the Second Amendment applies to the states through the 14th Amendment. And of course, that was before the Supreme Court's McDonald decision. There were a couple of 19th century cases that were read by the Ninth Circuit to say that the Second Amendment does not apply to the states. And at that time, I was doing a lot of research on Reconstruction history, and I ended up writing a book called Freedom, the 14th Amendment and the Right to Bear Arms, in terms of was the Second Amendment intended by the framers of the 14th Amendment to incorporate the Second Amendment. And of course, I concluded that was the case. But the Ninth Circuit didn't want to hear any of the historical evidence because they thought they were bound by the Supreme Court's 19th century decisions on the 14th Amendment. So their thing stood. In the meantime, the Ninth Circuit still had no Second Amendment jurisprudence because that issue was avoided based on the non-incorporation. Something happened in, I think it was 2001, the Fifth Circuit was the first circuit that in a major case held that the Second Amendment does protect individual rights. And following that, the Ninth Circuit, there was another challenge to, it was called the Roberti-Ruiz Assault Weapon Act. There was another challenge to that, which could have been disposed of under the Fresno rifle precedent, but instead there was a decision made, Silviera versus Lochner, by Judge Reinhardt, excuse me. I keep thinking Rehnquist. But it was a comprehensive decision arguing that there's no individual right under the Second Amendment. And so at that point, that line of thought gets reversed, of course, by Heller, and then McDonald reversed the line of thought that there's no incorporation. There's been a lot of Second Amendment challenges in the Ninth Circuit since that time. And it's been, if you're claiming that Second Amendment rights are violated by a law here in California or Hawaii or wherever, it's a pretty uphill battle in this circuit. Most of the cases have been decided adversely to the Second Amendment, contrast to some other circuits. The Fifth Circuit is known to be very favorable to Second Amendment challenges. But before this text history tradition really got more explicit, the way we used to litigate the cases was we would do what was the original understanding, and we would quote people like James Madison and some of the other people involved at the framing level. But another important thing that we did, because there was a lot of case law, it was basically tiers of scrutiny under the First Amendment, and that was whether something is a fundamental right. If it's a fundamental right, then you look at it in a way, you've got to have a compelling government interest to overcome it. So you've got strict scrutiny being applied in these kinds of cases. And so it was an easy thing to say, well, the Second Amendment's a fundamental right because it's in the Bill of Rights. A lot of the case law on fundamental rights tied that concept to whether it's in the Bill of Rights versus something that is some kind of implied right. Privacy or some of the things that just aren't enumerated explicitly in the Bill of Rights. And so we did make that argument for a while. And an interesting thing happened with that. We encountered then Judge Kavanaugh in the DC Circuit. Heller held that the kinds of arms that are protected are those that are commonly possessed by law-abiding people for lawful purposes. District of Columbia had a ban on many semi-automatic rifles, and so we thought this would be an easy, the low-hanging apple kind of case, because AR-15s, for example, are commonly possessed nationwide. It's the most popular rifle in the nation, and so we took that case and went to the DC Circuit, and in a 2-to-1 opinion, the circuit upheld the ban. And what was kind of ironic was Judge Kavanaugh said, well, they're arguing for the strict scrutiny standard, but the text history standard might not invalidate as many laws as the strict scrutiny standard would. And so anyway, he espoused the text history approach that I think Heller took that approach, but Justice Scalia didn't articulate text history in those simple terms. Heller looked at the text and it looked at the history, but there's nowhere in the opinion that it says, well, we're going to apply a text history approach like Bruen did explicitly. But Judge Kavanaugh in the DC Circuit did that in his dissent, and the case became known as Heller 2. We had the same plaintiff who was the original plaintiff in that case. So since Heller, and especially since Bruen, the name of the game is text and history. There's been a lot of criticism of that. You start with the presumption that an activity is protected. This is under Bruen. Is protected if a bearable arm is involved. In other words, is the type of arm a bearable arm, not like a cannon or something, and is the activity, does it involve keeping and bearing that bearable arm? And if that's the case, then the presumption is that the law is questionable, and then you go to text and history. And so if there's a national tradition and a history of that kind of regulation, then it may be upheld if it's tied to the founding era. And that would be the colonial laws were looked at, the laws in, at 1791 and up through part of the antebellum period. And then when it starts getting further into the years after that, the law needs to be consistent with the earlier laws. If you start getting something that is, especially in the latter part of the 19th century, that's inconsistent or has no precedent, earlier in the century, more tied to the 1791 period, then the law becomes questionable. Or if it's only something that existed in a few territories out west before they were even states. So there's a lot in Bruen. I think the Bruen test is something that lawyers can do easily, in the sense that it's very easy nowadays to look up historical laws. Not only are they on the internet, but there's Duke University Law School has a repository of historical gun laws, and it's very comprehensive. I think you have to, if you're going to cite to something from that, you need to find the original law to make sure it was transcribed correctly or the complete law is there. But I think that the Bruen methodology, while not perfect, is very workable, especially when you exclude the idea of intermediate scrutiny. I think just about every case under intermediate scrutiny went adversely to the Second Amendment, and that's why I think it was reined in by the Bruen case. And it's true, Adam said, that a lot of cases are coming out the same way, and I think that's because there's, some cherry picking of which history to look at and how general is the standard. So, and of course, in Rahimi, the court looked at the affray laws and the surety laws that were fairly close to the law that was involved in Rahimi. And the federal law required a judicial determination that there was a credible threat of harm, of physical harm to a family member. So that I think Rahimi correctly justified that law under the traditional affray laws and surety laws. Justice Thomas dissented from that, and you can see both sides of it when you read the decisions. But so we've gone a long way, and I should probably end my long digression now. But once again, it's a real pleasure to be here. By the way, we all know each other. I mean, we just met Judge Burns, but Bill here and Adam, we've encountered each other in other conferences and in litigation, and so it's kind of a small world to some extent.
So Bill, you pointed out that in the wake of Bruen, the cases that are coming to the courts generally fall into 4 categories. You've described the categories as who cases, what cases, where cases, and other or how cases. Can you explain these different categories and give us examples of the kinds of cases that fall into each, and what historical evidence is relevant to answer these questions?
Sure, and thank you, Judge Burns, and thank you to the Ninth Judicial Circuit Historical Society, my fellow panelists, and all of you. I can certainly try. So there's been a flood.
You may want to move your mic a little closer to you.
Okay. There's been a flood of litigation since Bruen, as many of you are surely aware of. But I think we can essentially categorize it into these sort of 4, largely categorized into these 4 categories. So you have the who cases. Those are laws, cases about laws, about who's allowed to possess, acquire, or carry firearms, for example. So cases challenging laws, age restriction cases, laws prohibiting those under 21 from possessing or carrying firearms. We had, Adam talked about this, we've had differing results from courts in these cases. This is in contrast to before Bruen, when courts were essentially universal in upholding age restriction laws. So what are some of the cases that most recently the 10th Circuit, just a couple of weeks ago now, I think, issued a decision upholding a Colorado law, which was a law raising the age from 18 to 21 for being able to purchase a firearm. In that case, interestingly, the court didn't do a historical analysis. Its analysis was based entirely on the text of the Second Amendment. We can talk about that in a little bit. So courts are not entirely restricting themselves to a historical analysis. Another interesting case in this who area to keep an eye on is a still pending age restriction challenge in the 11th Circuit. It's a Florida case which was passed after the Parkland mass shooting in 2018 that, much like this Colorado law, restricts those under 21 from purchasing firearms. There had been last year, so March of last year, a 3-judge panel of the 11th Circuit considered that law and upheld it under the Second Amendment. The whole court then vacated that and has now reheard it en banc. An interesting issue talking about the historical analysis that was a a focus of the court in that case was what is the right time period to be the primary focus for that historical inquiry? Is it 1791 when the Second Amendment was ratified, or 1868 when the 14th Amendment was ratified, which made the Second Amendment, as we know, applicable to the states? The three-judge panel in that case, they said it was 1868. So then they relied on a multitude of Reconstruction era laws, which were almost, very much like the Florida laws, restricted those under 21 from purchasing firearms. So we'll see what the panel does. Personally, I think that the court, like in Bruen and Rahimi, the court didn't resolve that question of is the primary focus 1791 or 1868. I think the en banc 11th Circuit could do that as well and still consider properly those Reconstruction era laws, earlier historical evidence, including there's common law evidence around the founding era that restricted those under 21 from acquiring firearms. So we'll see what happens in the 11th Circuit, but that's an interesting issue that could arise out of that age case in the who section. Then we have what cases. So that's the second category. These are restrictions, or cases about restrictions to certain types of arms or features of weapons. The primary example, the one we think about most, are challenges to assault weapons and large capacity magazine restrictions. Almost entirely those cases, certainly at the Court of Appeals level, have before Bruen and after Bruen been upheld, and the challenges have been rejected. Notable exception is right here in this court. There were a couple of cases, as I'm sure many of you are aware of, by Judge Roger Benitez, who found that California's assault weapon and large capacity magazine laws were unconstitutional. You might not be surprised to know that I disagree with those rulings. But that case is those rulings are now stayed. That case is on appeal, or both cases are on appeal, and we'll see what the Ninth Circuit does. We're first going to, I think, hear from the en banc Ninth Circuit about the large capacity magazine case. Then we'll hear about the assault weapon case. So that's the Ninth Circuit. That we don't have a post-Bruen decision on assault weapons and large capacity magazines. 5 other circuits have actually considered this question since Bruen, and they've all rejected those challenges and upheld the laws. So we have a case out of the First Circuit, the Third Circuit, the Fourth Circuit, the Seventh Circuit, and most recently the DC Circuit. I'd point out the Third Circuit was not, the case itself wasn't on the merits, the decision, though one judge concurred and did fine for the state on the merits. I'd say if you want to sort of delve more into this area, a really interesting decision on both sides is the Fourth Circuit's decision in a case called Bianchi versus Brown. It's a case involving Maryland's assault weapon law. I certainly personally agree with the majority opinion written by Judge Wilkinson, which upheld that law, looking at both the text, under both the text and the history. Some of the, what was the historical analysis? What historical laws did it look at? So what Judge Wilkinson's opinion did was find, really inconsistent with Rahimi, a principle of being able to restrict particularly dangerous weapons of the time. So, for example, 18th century, there were restrictions on things like trap guns and gunpowder. 19th century, you had restrictions on Bowie knives and things called pocket pistols. Going on to the 20th century, where the opinion looked at, and you had restrictions on machine guns when they came into play, high capacity semi-automatic weapons, and leading us to sort of the modern laws on assault weapons and LCMs. He found that to be a consistent historical tradition, or he and the 9 other judges that agreed with him, a consistent historical tradition to uphold the law. If you're, the other side, Judge Richardson wrote a dissenting opinion. I, recommend people to also look at that and see what sort of the other side of this analysis is. That case is, been decided. There's now a cert petition that's garnered a lot of attention. There are also cert petitions actually from the First Circuit and the Third Circuit case. The Supreme Court denied cert right after Rahimi in the Seventh Circuit case I mentioned. So there is no circuit split yet. So my view is this is not, I don't expect the court to take up cert, but obviously, we'll see what happens. That case has garnered some attention at the Supreme Court level. So you have the who cases, the what cases, the where cases are the third category. That's where we think of these sensitive places or location restriction laws. So there have been two major Court of Appeals cases at the federal level since Bruen, and actually since Rahimi. The Second Circuit, which is a case we included in the materials, a case called Antonyuk versus James. Before Rahimi, they upheld a number of restrictions that New York had put into place, including restrictions on carrying guns in playgrounds, parks, zoos, bars. The Supreme Court after Rahimi, GVR that case granted, vacated and remanded, say, why don't you reconsider this in light of Rahimi, which they did with a number of Second Amendment cases as a typical practice. The Second Circuit said, well, Rahimi, we think only bolsters our approach. And they did at the time, just, a principles-based approach. They looked at a bunch of laws, found principles that supported them, and found that they were being upheld. So they did, said, as I said, Rahimi bolsters our approach, and they reached the same conclusions on the sensitive places laws upholding them. As I said, the Antonyuk case is in the materials. I would recommend it both for its analysis of the various sensitive places, and it has I think, a very good analysis of some of the more general methodological issues that came out of Bruen and Rahimi about things we can talk about later, but I think it does a sort of a broader approach on that. So that was the Second Circuit. I said there's two circuits. The other one is right here, the Ninth Circuit. Very recently, a case called Wolford versus Lopez considered a bunch of location sensitive places restrictions from California and Hawaii. It largely upheld them, so it upheld many of the same zone, New York, bars, parks, playgrounds. It did, make sure I get these right. It did say that some, at least at the preliminary injunction stage, were unconstitutional under the Bruen and Rahimi analysis. So banks, hospitals, places of worship were a few of the examples there. So, again, we have largely being upheld, but still some, being found to be unconstitutional, at least at the PI stage. So those are, who, what, where. I said there were four. I didn't lie. The how restrictions, which is a bit of a grab bag, I think, because I needed a fourth category. But these are things that sort of affect the process of acquiring or carrying arms, or the manner in which you carry arms. So I think you can group things like background checks, waiting periods, licensing requirements into this. One interesting, Steve talked a little about the Fifth Circuit. One interesting post-Bruen case is from the Fifth Circuit in this area, a case called McCrory versus Garland. It upheld the federal, a provision of the federal Bipartisan Safer Communities Act, which had an enhanced background check for 18 to 20-year-olds, and included with that was up to a 10-day waiting period for them to be able to purchase a firearm. So the court there, we talked a little about text. The court there relied entirely on the textual approach, saying that, this isn't a restriction on keeping or bearing arms. It's only sort of a slight delay in order to purchase them, and that is not, it's not a de facto prohibition, which would be needed to sort of place this within the textual bounds of the Second Amendment. So the Fifth Circuit, a court, as Steve mentioned, not one to be, known as the most sympathetic, perhaps, to the Second Amendment or gun regulation. Not sympathetic to gun regulation, sorry. Upheld this law. So a number of interesting decisions. Happy to go into more detail later, but I think that gives us sort of a overview of what is out there in the landscape of post-Bruen and post-Rahimi now Second Amendment litigation.
Something Steve mentioned reminded me of my ninth grade algebra professor who said this is going to be easy. It was never easy. In the relatively brief time since Bruen was issued, federal judges appointed by Presidents Reagan, George H.W. Bush, Clinton, George W. Bush, Obama, Trump, Biden, all judges appointed by different presidents have opined that Bruen's test for gun regulation provides a difficult and unworkable basis for deciding constitutional questions. And it pushes the court, this is the complaint, pushes the courts toward unreliable, unreasonable, and unjust conclusions. So I put this to you, Professor Winkler. In your opinion, are these valid criticisms? And if so, how might the Supreme Court correct the problem?
Sure. Well, I think there's two things I want to say about that. I mean, so first and foremost, it's a new standard of review, a new test, a new way of doing constitutional law. And I know that, some of the justices have said, well, we always paid attention to history. That's true. History has always been part of constitutional law, but never quite as a standard of review in the way that has been adopted in the Second Amendment. The Second Amendment's a perfectly good area to try out this new originalist approach to judicial review, because there isn't a ton of case law that the court has to distinguish that's been decided under tiered means and scrutiny, like strict scrutiny or intermediate scrutiny. So you're writing on a blank slate. So it's a little bit easier to do that and to maintain, the only handful of Supreme Court precedents. And I do think that any new test that you would apply, that you give judges to apply, that's different from what they were taught in law school, different from what they've done their whole careers, different from what they've seen as lawyers, is going to be difficult. It's going to be a challenge. It's a new thing to do, and it's a new way of doing constitutional law. And I think that, strict scrutiny and those standards didn't just emerge overnight. They were developed over time. And the reason why courts are really, I think, pretty good at applying those tests, and why we get pretty consistent results from those tests, although any student in my con law class knows that we teach a whole bunch of rational basis cases where the courts strike down the law, right? I remember one student said, because we have like the disability case and the sexual orientation cases, and one student said to me, are we ever going to read any rational basis cases where they actually uphold the law? Suggesting that, that even under those tiered scrutinies, you get some different answers. So I think part of it's just a lack of experience, and as courts get more experience and as it gets applied in more areas, you'll have, I think, a little bit more certainty coming out of it, perhaps. We'll have to see. But I do think the text, history, and tradition approach has some very serious theoretical problems that the court hasn't really thought through yet. And, number one, is the assumption true that when we see legislatures regulating guns in a certain way in the mid-1800s, that's indicative of the original public understanding of the Second Amendment? I don't know that it is. It may be, but unless we have legislatures actually saying that, then maybe not. Maybe they're not really even thinking of the Second Amendment. Indeed, for most of American history, the Second Amendment was not incorporated to apply against the states. The 14th Amendment changed that, but only in the text, not in terms of constitutional doctrine. That doesn't happen until 2010, really. And so you have all these states that are adopting gun laws, and we're saying, well, they're not even thinking of the Second Amendment, because those states don't view themselves as bound by the Second Amendment. They may have a state right to bear arms provision that they're responsive to, but they're not thinking about the Second Amendment. So it's not clear to me that that assumption's right. The idea that the absence of regulation suggests that the original public understanding is not to allow regulation in that space seems to me a big stretch, right? There's a lot of reasons why lawmakers don't act. Number one, they don't act to the limits of their power at all times, and we hope they don't do that. Let's pray they don't. Number one. Number two, they may not act even if they think they have the constitutional authority, because they can't get a consensus or they can't get enough political support or mobilization for some particular reform. So the idea that the absence or existence of regulation tells us something meaningful about the original public understanding may be true in some cases. It's not true in all cases, and the court's test does not differentiate that. There's also, I think, pretty significant theoretical issues with looking at history and tradition. Number one, that history is racist. History is sexist. History is profoundly unequal and unrepresentative. Why we would think that, lawmakers, a lot of gun laws in American history are racist gun laws designed to keep African Americans and other minorities as second-class citizens. What do we do with those laws? Are they totally irrelevant to how do we think about government power over guns? Maybe we say we're past that age of racism. We don't look at that at all. Maybe that's the right answer. At the same time, maybe what we're seeing also is a reflection of, at the time, the legislature's understanding of what their regulatory authority over guns was, and they thought they could use that regulatory authority in ways that were racist and sexist or otherwise discriminatory. And even if we get beyond that problem, we have legislatures in the 1800s that are profoundly unequal, that are profoundly unrepresentative, that that it's hard, when I tell, I tell someone who's a total layperson that the court is going to decide whether a current gun law today is constitutionally permissible by looking to see whether there were similar regulations in the 1800s, they think I'm joking. They're like, what? Like, what sense does that make? Society has changed so radically. Government power has changed so radically. The technology of firearms has changed, certainly a lot since the founding era. So they scratch their heads because history is, the historical regulations that were adopted in the 1800s just don't seem like a particularly good model for how you'd regulate society today. And the legislatures themselves were unrepresentative. Indeed, when we think about it, the text, history, and tradition approach approaches legislation today that regulates guns with skepticism, and that we have to see some similar laws in the past. But why are we looking at the legislatures of the past when they regulate guns without skepticism? Like, why do we think that the legislature today are all looking to burden gun rights, but the legislatures of yore were never interested in that? They were just honestly applying the original public meaning. It just doesn't really make a lot of sense, I think. And I think this comes through even in the Bruen and Rahimi cases as they're decided. Bruen, that makes this big, strong claim about history and tradition and the necessity of finding historical analogs, drops a footnote and says, well, nothing in our opinion casts doubt on shall issue permitting. There's no shall issue permitting in the 17 and 1800s. Like that the shall issue permitting is totally a 20th century invention, and yet Bruen says it's okay. And I think that just goes to highlight that whatever standard of review you apply, whether it's strict scrutiny, intermediate scrutiny, or text, history, and tradition, the biases of judges and of a society and the kinds of ways we think about problems today will infiltrate and shape the opinions. That's something that we want to avoid when they reach the decisions we don't like, but when they reach the decisions we like, we kind of think it's a good idea.
So Steve, let me come back to you for a minute. Maybe I gave short shrift to this. You pointed out when I raised this in our preparation meeting that text and history is relied on in a lot of other contexts, not just the Second Amendment, but you mentioned freedom of the press, search and seizure, that courts have looked at text and history before. So it's not like this is all that novel. Do you want to speak to that?
Yes, I'd be glad to. What is the purpose of a constitution? What's the purpose of Bill of Rights? Bill of Rights, St. George Tucker and his commentaries on the Constitution, commentaries on Blackstone, published in 1803, made the point that the Bill of Rights is not just to inform government officials, it's to allow basically the most uneducated people to know what their rights are so they can protect them. A Bill of Rights is not there just for government to decide how it's always to be interpreted. I mean, it's something that the people at large need to be informed about, and that was the whole purpose of it. It's pretty short and concise. It doesn't give you information for every possibility in terms of protecting it or deviating from it. That's worked out through the historical process, but you need to have some kind of guide. That's the whole purpose of a Bill of Rights. And so with that in mind, why did we get the Bill of Rights? And a big part of that was because of the encroachments by the Crown on what were considered the rights of Englishmen. They still called themselves Englishmen until the Revolution and the states declared their independence. But Blackstone's commentaries has a lot of material about what were considered rights of the subjects. They were not citizens, they were the subjects. And we carried over a lot of that, but then we improved on it. And so we end up with, for example, the English Declaration of Rights of 1689 protected the right of Protestants to have arms. And our Second Amendment doesn't discriminate against people based on religion or race or any other subject like that. And so the reason that we have to look at what was the public understanding when the Bill of Rights was adopted in 1791? And that's why looking at these old laws give information. That doesn't mean, and Rahimi makes this clear, that we have to have a dead ringer. It has to be a law that's exactly like that, but how did the framers and the public at large look at what's permissible and what's not permissible? If you have a Bill of Rights, it's there for a purpose. It's not like the rational basis test. And I've hardly ever seen a law that was invalidated under the rational basis theory. But Adam, you've seen those cases, and that's interesting. But most of those cases that come up, the law gets invalidated because the test is there any possible conceivable basis that the legislature passed this law? And you can always think up reasons, virtually always. So we don't use rational basis and we don't use intermediate scrutiny, the means ends type test. And but directly, Judge Burns, answering your question about about other rights under the First Amendment, some of the classic cases rely on history. They look at freedom of the press is a good example. The Near versus Minnesota from 1931. The court goes back and looks at prior restraints and censorship and all of that, going back to the British infringements on that right, and how the right was interpreted in colonial times and up around the framing period. And if you look at Bruen itself, it cites the case United States versus Stevens, decided in 2010. There was a federal law that tried to criminalize video and other images of animal cruelty. And the court took a hard look at that and said, where's the historic basis for that? In other words, the government could not come up with any old laws that did that or any exceptions to the First Amendment. And so the Supreme Court invalidated that. But those are just two examples of cases under the First Amendment where the court does look extensively at history. And if you look at the Fourth Amendment cases, the Boyd case from 1886, that's a classic decision on the Fourth Amendment and having to do with writs. They go back into the English history, writs of assistance, and these general warrants that were issued, and that was one of the main complaints that led to our revolution. And so in terms of the Fourth Amendment, like there's a lot of exceptions that the Supreme Court has carved out, but if you look at the classic cases, and if you had like con law in law school, you'll remember those cases. They look at the English history and they look at our history, how we improved on the English model. So it's very much precedent. It's been very much something that judges and lawyers do in terms of looking at history. And I think the whole point in Bruen of looking at the kinds of laws that were on the books at the time of the framing and then shortly thereafter, that gives information. If there's once again, this is not just made up for Second Amendment cases. There's one of the recent First Amendment religion cases, establishment of religion cases, where there were laws passed in the second half of the 19th century, and there were no such laws earlier, and the court said that's not good enough. The public understanding at the time the Establishment Clause was ratified was that was expressed in the kinds of laws that were passed, maybe on the books at that time, or in the first few years, first few decades of the 19th century. So this is not. What Bruen did was to borrow from what the court has done in a number of other Bill of Rights guarantees. So I think, okay, yes, so it's hard to apply maybe when it's a new test, but think about there was no right incorporated against Bill of Rights freedom incorporated against the states until the late 19th century, the Just Compensation Clause. And free speech, that wasn't much to write home about. And I mean, if you look at the cases in the 20s, they're upholding convictions of people for arguing that the draft was involuntary servitude or just making political arguments that were adverse to the war effort. I think Eugene Debs was put in jail because of advocating socialism. And so it wasn't really till the 30s that the court started giving meat to free speech and freedom of the press. And of course, I guess it was harder for courts to deal with it then. You know, but before that, there wasn't much recognition of those rights. And so by the same token, the Second Amendment's kind of a late bloomer in terms of the court really recognizing the fact that it really is part of the Bill of Rights. But I think, as Bruen makes clear, in terms of looking at the history of laws, that's what lawyers do all the time, and judges do to resolve cases. So that's my response, and I'm sticking with it.
All right. So I think the point's been made here that this new test arises from the concept of originalism. Originalism, of course, investigates the natural construction of words and phrases, relies on evidence of the text's historical meaning. Two law professors, Professor Joseph Blocker and Eric Rubin, have said, well, Bruen's not merely an application of originalism, but it's what they have called, and they've coined this term, originalism by analogy. In other words, we're going to look at this and try to analogize. I think Justice Barrett, in her concurring opinion in Bruen, said this, or maybe it was Rahimi, but she said, look, the problem with that is that there's just levels of generality here.
Right.
And this has come up, of course, you know, with defining rights under qualified immunity. You know, they're supposed to be defined very narrowly. And she says there's going to be a problem with overgeneralizing the analogy. And then the other problem, I think, stems from Rahimi, because doesn't it, and this is to the three of you, doesn't Rahimi put a gloss on Bruen by saying, look, it's not just the text of these old laws that you're applying, it's the principles that are embodied in those old laws that you compare to the principles in these new regulations. Seems to me that leaves a lot of room for subjectivity on the part of the judge looking at that. Both of those things do. I put it to the three of you to comment on that.
Well, I think, you know, what it does, and, you know, responding to this, Steve talked, has talked about that this test is sort of easy to do and these laws are easy to find. And I think that, you know, I'll get to the answer. I think that's important because that's how we get to these principles, right? The court is telling us is to first start with the history. So the history is not easy to find. We don't have the full, even close to the full comprehensive view of even what the historical laws are. So I included something in the materials from, you know, the person who manages the Duke Repository of Historical Gun Laws, which is the sort of largest collection that we have. He talked about these sort of, in his view, sort of massive difficulties and limitations of what he's been able to uncover. He considers the repository to be the tip of the iceberg, and the idea that we have a comprehensive view was, in his words, dangerously misleading.
Yeah,
So,
I think you corrected me and told me, no, you can't look these things up on Westlaw or Lexis.
no,
They're
you
not
can't-
there.
No, and you know, just look for historical. You know, you look on. I said to before here. Let's look at what Westlaw considers historical session laws for New York, just for curiosity. It goes to 1990. Like that's not that's not useful for this analysis, right? So what you have to do is there are online databases. Some are free, some cost money, that are varying degrees of utility. Things like, you know, Google Books, Hathi Trust is a database. You can look at the making of modern law and do, you know, searches of various types to try to get across to find some laws.
The Duke repository that the two of you have spoken of, is that available online to
It is.
practitioners?
You can go to the Duke Firearms Law Center website and go to find the Duke repository. And I would recommend that. It's got a lot of good materials, and it keeps growing those materials because people are now, you know, trying to search for them. But that process is a difficult one, both the online process, which is, you know, has difficulties in what is available online, how to find that through searches, which is not just like you go to the already compiled one database and enter the very easy search terms. You've got to figure out what is the language in that law and see if you can do another search in another database to maybe find something that is like that. So to just give an example of some stuff that we've done at Everytown. So we've been looking for, because of litigations that Steve and I are both involved in, historical parks laws. It's historical laws restricting the carrying of guns in parks. Before we started looking at Everytown, the Duke Repository and other sort of sources that have been collected had essentially single-digit laws. It wasn't something people were looking for, so it wasn't something that was there. So if you had went to them at that point, you just said, oh, there are like 3 parks laws, right, or something of that nature. We started, looking in these databases, finding what, figuring out search terms, looking in various databases that I talked about, or newspaper databases where some of these, these ordinances will be, most of what we've done has been online, some, paper copies, because a lot of these sources, especially at the local level or at the state regulatory level, will be in, some sort of local archives or historical society. So in months since Bruen, and I guess now years since Bruen, we spent enormous amounts of time searching for more parks laws, as that primarily through these online sources. And now we've uncovered from what I said were single digits to well over 100 laws, approaching now 200 laws restricting guns in parks. So, this continues to grow. We're, like finding laws all the time, 30 just the other day, just from new ways of framing searches. And I said, this is without very much in the way of archival paper copy research, or much of that stuff is going to be even handwritten, not available online, can't search for it, got to go to the old microfiche at the best, or maybe paper. And then that's, is this stuff even available? Some of these laws, people didn't think to keep them from some places. So in short, it's not easy to find, and it's not comprehensive. And that's what sort of the, at least some of the raw materials are for deriving these principles. I think you take historical laws, you take other history, you take, people like Adam, who has, I know, been an expert in cases, talking about some of the context surrounding that history to explain why or why not a law might have been enacted. What explains, for example, why, we see arguments in some cases about historical context, why, we had one argument is we have lots of repeating firearms and there weren't any regulations back in, the founding era. If you look at the history, though, in which one of the things we include in the materials from a UC Berkeley professor, Professor Brian DeLay, actually looking at history, these were curiosities. This was not something anyone would regulate. As Adam talked about, you just don't regulate to the constitutional maximum. You regulate when there's a reason to regulate. So a lot of these issues sort of we're dealing with to sort of develop what that principle is. And in the sensitive places area, some of the best guidance we have is Justice Barrett's Rahimi concurrence, which you talked about, where she talked about the sensitive places principle and said, didn't give much more guidance than that. So we're searching for what that means. And she raised that question, what is the level of generality? I think when you have, specific regulations, you don't really need to work that hard to figure out the constitutionality, but other restrictions, can take a little more work.
What about the principles, Adam? Does that add later a gloss to the Bruen test, where you now say, I don't have to find a historical twin. I know that's got to be maybe a historical cousin, but I don't even have to find that anymore. I just have to find a law where I can intuit that the principle is the same in the modern regulation that's being challenged.
Yeah, I think one area of potential disagreement between Professor Holbrook and myself is over what impact Rahimi had on the Bruen test. And I know Professor Holbrook wrote a blog post about this, saying that he didn't think there was a significant revision of the test in the Rahimi case. And it's clear that the majority in the Rahimi case does not purport to revise the test. They purport to apply the test. I think in practice, however, the Rahimi decision really resets the Bruen test in really fundamental ways. And for instance, the court does, I think, at least three different moves that really change the Rahimi test, the Bruen test. One, the court says, and it makes clear, we don't need to find historical laws that are very similar to this law. Now, Bruen also said you don't have to find twins, but then the analysis in Bruen was really a search, if not for twins, then for, for laws that looked a lot alike. And it wasn't have to be a twin and exact, but it had to look a lot like this. And indeed, the lower courts in the wake of Bruen did a lot of that. We want to find a law that looks a lot like this. Doesn't have to be a twin, but we want to see it at least be a cousin or something like that. And I think what Rahimi does is move away from that. The court cites two laws to justify the ban on possession of firearms for domestic violence, for domestic abusers subject to a restraining order in the Rahimi case, the surety and affray laws. The surety and affray laws basically were ways in which you could either criminally punish those who go about armed to the terror of the people, so use their arms improperly in public. And the surety laws were basically bonding requirements that if someone was thought to be a danger, they could have to post a surety bond, and they could, lose that bond if they actually did something dangerous. Well, the two things that the surety and affray laws did not do was, number one, prohibit anyone from possessing a firearm in their home for personal protection. Exactly what the DVRO ban in Rahimi does. That's a big, big difference. Second, one of the things the surety and affray laws don't do is they don't prohibit anyone, even if you're under the surety bond, from using a firearm for legitimate self-defense. The DVRO ban does do that. So if you look at the surety and affray laws and try to compare them and say, well, that's the historical analog, I think the thing that's most remarkable about those laws is how different they are from the DVRO ban rather than how similar they are. And so I think the search for the court says, well, we don't have to find laws that are very close. And then the court in Rahimi finds laws that are not very close. And that's a big difference. Two, the search for principles rather than historical analogs. I think that's important because that places the question at a much higher level of generality. I don't have to actually find particular laws and say this looks a lot like that. I say that law doesn't look like this law, but it was about something similar. It was about dangerous people, prohibiting dangerous people from possessing firearms. And that move towards principle adds a higher level of generality, makes it more likely you're going to have judges, their views influence the underlying decision, and certainly makes it easier for the government to prove that a current law is justifiable by looking to historical principles rather than actual laws on the books. And the third thing is that Bruen was very much interested in mathematics, counting up the number of laws that were on the books, the number of people who were affected by that law, whether the law was actually enforced. Rahimi doesn't do any of that. And so I think, and we're seeing in the courts since Rahimi, all three of those moves being echoed by the lower courts for the most part, where not entirely, but we're seeing less focus on historical twins, less focus on the numbers, and more focus on broad principles that I think are very different than what Bruen was suggesting.
So Steve, let me give you just a short second to respond to that because the two of you are in tension on this issue.
Yes, we can't overgeneralize here in looking for analogs. For example, what has the government been citing in terms of what are the analogs to support various restrictions? And this goes to the federal government as well as some of the states. Why don't we look at the fact, well, they disarmed Tories during the revolution, and therefore Tories were considered dangerous, and we can disarm people for whatever dangerous reasons today. And so that's not a good analog because we were in a wartime. Tories and patriots were killing each other, so I guess you could disarm them, and that would not be quite as extreme. We were tearing up their presses and destroying their printed matter, their propaganda, just like they were doing it to us. So that's war. So these principles don't count then. What about the slave codes and the black codes? In Rahimi, in the Fifth Circuit, the government lawyers were citing the black codes. You can disarm African Americans, and therefore that's precedent for for today's law disarming domestic abusers. They finally got called on the carpet. During the oral argument, Justice Thomas's first question to Solicitor General Prelagar was, how come you were citing the slave codes and the black codes in the Fifth Circuit, and now you're not doing that in your briefs? And so finally, the government conceded that that's not a good analog. But I think I would defend the examples of the Frey laws and the surety laws as being very close to the type of law being upheld here. A judge makes a determination that there's a credible threat to physical safety of certain people. Let's look at the Frey laws, first of all. It was a common law offense to go armed in a manner to terrorize other people, otherwise known as going armed with dangerous and unusual weapons. The terror element was there. That came out in the English case law, and then that was adopted in every state. In every state, it was a common law offense to go armed in a manner to terrorize other people. It was a crime. They could incarcerate you for that. And by the same token, under the surety laws, they differed by state. But if you could prove before a court that a person was menacing you and there was no justification, then that person would have to find sureties to keep the peace. So that, in other words, there'd be a judicial determination that this person is going to breach the peace or otherwise threaten people. And it's like posting bond today and being held potentially in contempt if you violate the terms of a court order. The bond gets forfeited and you go to jail. So by the same token, with both of those laws, you could be incarcerated. You could be incarcerated and you would have no right to bear arms while incarcerated. So the federal law at issue here was actually a better deal. You don't get incarcerated, but you cannot bear arms. So on the one hand, the laws that were cited as the proper analogs could be harsher than the law at issue that was upheld. And so I don't pay too much attention to the fact that the court used the term principles in Rahimi. If you look at the site for that, Bruen itself makes reference to the principles that were involved. And what were those principles? Those principles had to do with looking at text and looking at history. The Rahimi case itself applies these types of laws, a phrase and the surety laws, and doesn't go further than that and say there's some kind of like principles that there's overgeneralized principles here at work that, oh, somebody's dangerous and therefore we can disarm them. Those were two very, very much in place laws at the time of the framing. And just one more point about Westlaw and Lexis. There's a lot of stuff you cannot find on Westlaw and Lexis that have to do with constitutional interpretation, certainly not just in the Second Amendment field. If you look at once again, search and seizure issues or maybe right to counsel, or whether criminal trials have to have unanimous juries, things like that, you're not going to find it on Westlaw or Lexis. You're going to find it by doing historical research. What was the practice at the founding? And that gives you a lot of information. But in terms of also which laws do we look at? Do we look at 1791 versus 1868? I think it's perfectly legitimate to look at 1868 laws if those laws were consistent with the 1791 laws. But if you think about what's being argued for here, if you say that the 1868 laws are the ones that count, even if they're in conflict with the 1791 laws, you better think about the implications for the other Bill of Rights guarantees, because every one of those has been interpreted in terms of the founding period. What 1868 does, the 14th Amendment, is to incorporate that original intent, that incorporates the Bill of Rights and what the thinking, the original understanding that went along with the Bill of Rights when it was adopted in 1791. So if you look at the common understanding or the congressional globe, the debates over the 14th Amendment, what led to it, you'll basically finding that they're seeking to incorporate those Bill of Rights guarantees that were considered fundamental. Senator Jacobs, in his introductory speech for the 14th Amendment, made that point. He didn't say every single Bill of Rights guarantee, like civil jury trials under the 7th Amendment. He didn't say that. He said the fundamental rights, and he explicitly mentioned the right to keep and bear arms. So, once again, there's a lot of sources by which you determine whether a law restriction might be constitutional or not under any of the Bill of Rights guarantees. And you're not going to find all the answers on Westlaw or Lexis, but you find the precedents that way. But in terms of the historical reasons why we have these different guarantees, you've got to look in a lot of other sources.
So Johanna, I see you. Is our time close to being up?
2 or 3 questions.
Right.
For a total of maybe just about 10 more minutes.
Okay, will do. Pretty sure we're going to have questions. Let me mention one other thing too before we get to the questions. Like every presentation, this goes much quicker than what we planned for. There are some criminal practitioners here, Bill, and I was going to have you talk about the as-applied challenges now being made to criminal statutes, that, well, this felony is not very dangerous, and so it's unconstitutional to subject this guy, for example, to felon in possession of a firearm, or even take the firearm away from him. So for those of you who are interested in that issue, and we're seeing these as-applied challenges, I think probably more frequently than anything else to the criminal statutes.
For sure.
You'll want to talk to Bill because he's got a lot of information on that. That said, are there any questions for the panel? Yes, sir.
Question is something that, but it has to do with the fundamental premise of Bruen being a new test or a new standard of review. And my question relates to the California Court of Appeal case, People versus Bocanegra. And the quote that I just would like to get you to give your thoughts on is, the Supreme Court in Bruen did not create a new test applicable to Second Amendment challenges. Rather, it clarified the contours of Heller. Thus, the majority made explicitly clear it was applying the test initially set forth in Heller.
Okay, let me repeat that because we have people watching on Zoom and they may not have picked up your voice. There's a California case that takes the position that Bruen did not create a new test. Rather, that applies the test that was first, if there was a test, first set forth in Heller. You want to speak to that?
Yeah, I mean, it's a fair point. It's clear that Heller didn't make crystal clear what the test was, right? And that, as evidenced by the fact that every circuit court in the wake of Heller applied a 2-step intermediate scrutiny that was completely inconsistent with the text, history, and tradition approach. So I think certainly Justice Thomas and Justice Kavanaugh and the originalists on the court view the Bruen test as a manifestation of the Heller idea behind Justice Scalia. But I don't think anyone who's studied constitutional law over the last 40 years would say that the way we do First Amendment law is we determine whether government regulation is constitutionally permissible solely by looking to text, history, and tradition without tiered means and scrutiny. That's just not how constitutional law has traditionally been done. History is a function, and Professor Holbrook talked about that, and he's absolutely right, and I agree with him. But whether we were to say it's a new test from 2008 in the Heller case or a new test in 2022, I think the point I was making, I think, still remains, is that judges are not that familiar with this test. And to know whether it's a good test or a bad test or predictable or subject to manipulation more or less than tiered means and scrutiny is going to take some years of actually using the test and practicing with it. And we haven't had that yet, and we're just getting it now. And so I think, whether we say theoretically it stems from Heller or comes from Bruen, it clearly became the doctrine after Bruen, and every court now applies text, history, and tradition in that way, that at least was imagined by Bruen. Finally, I mean, I do think that one more bit of support that Rahimi completely revises the text, history, and tradition test is the fact that Justice Thomas dissented in Rahimi, and dissents with a very forceful argument against all of the historical analysis that is offered by the majority and by Professor Holbrook too. Not to make it personal, but that same analysis was rejected by Justice Thomas. Clearly, he thinks that Rahimi is, misusing his test at least.
Other questions? Yes, sir.
First of all, thank you for being here and presenting to us, the public, your stance on the Second Amendment. Most recently, our sitting president, Joe Biden, in a public forum, he said that the Second Amendment was never meant to be absolute. He said that. And that makes me wonder. So if the Second Amendment is not absolute, how many of the other amendments are not absolute? The first, the second, the fourth, the fifth, the 28th? That makes me wonder. A sitting president stands before his public forum and says the Second Amendment was never meant to be absolute.
Okay.
So how do you stand by it?
The question put to the panel is that President Biden made the statement that the Second Amendment is not absolute. Is that consistent or inconsistent with the jurisprudence of the Supreme Court?
I can give you a couple dozen cases where the Supreme Court says no right under the Constitution is absolute. Like, that's pretty standard constitutional doctrine today. So I think what he's saying is not far from what the Supreme Court has said repeatedly about constitutional rights. Now, I think there's a debate happening right now about whether that's the right way to think about constitutional rights. And I think one reason why we have the text, history, and tradition test emerging in the Second Amendment area is the a discomfort among originalists with that idea that a right is not absolute, and that government, if it has good enough reasons and adopts a narrow enough law, it can violate that law or burden that law. So I think there's some real debate about that.
Could I just add a comment on that? It depends on what absolute means. You'll have some proponents of never finding the Second Amendment violation will say, well, no right is absolute. But that's not the question. The question is whether the specific law infringes on a constitutional right, whether it be the First or the Second Amendment or whatever. And it's true, for example, there's a right to counsel, and there are restrictions. Like, I used to do court-appointed work. I could go see the prisoner. I would have to let them know. They'd have to let me in. It wasn't like unlimited access. It wasn't like the incarcerated guy got to come to my office, for example. And so, yeah, there's different ways of exercising these constitutional rights. But I think what we've heard over and over, when somebody says it's not an absolute right, what they're really getting at, frequently at least, is that, well, you can see what's coming. We're going to argue that whatever the restriction is, it's okay. And so, but what we really have to do is to look, again, once again, with text and history. That's the standard now. And you look at the restriction, whether it's something that is within the contours of this nation's tradition of history and tradition of regulation.
Johanna, do we have time for one more question? Okay. Yes, sir. Yes, sir. Can you speak up too, please?
First federal government was in North Columbia. There's an argument that 1791 only be used with District of Columbia or federal government versus those that believe that 1868 is their appropriate state.
Okay, so the question is, in looking at history and looking at analogs, Are we limited to those in 1791, or can we also look at state analogs from the post-14th Amendment enactment?
Well, I think, no matter what your answer to that question is, and I think I tried to say this earlier, you can look at the full sort of range of history that the Supreme Court itself did that in Heller and Bruen and Rahimi, and left open this question: should the focus of our analysis be 1791 or 1868? Interestingly, you mentioned states versus federal government. Obviously, Bruen was a case about the state law, and Rahimi was a case about the federal law. Yet they, left this question open in both of those cases, not saying that it would answer one way in one case or one way or the other, but instead, we don't need to answer this question because we can look at sort of the full scope of history. So I think that is the, best way to look at it. There are certainly originalist scholars who will say, should we look at 1868 just for state laws, or should we look at, 1791 for federal laws? I think that, there's also federal scholars, including with the Supreme Court, original scholars, including who the Supreme Court cited in Bruen, who would say that 1868 would apply to both the federal government and the states if you're going to make a choice. But as I said, I don't think you do need to make that choice. And I think the Supreme Court has rightfully so far not had to make it and still look at the full range of history.
I've been under the assumption that almost all the analogs are colonial or state analogs, that they don't flow from enactments of Congress and the federal government. Is that your experience too?
Sure. I mean, most gun regulation has always been done at the local level or the state level. You didn't have real federal gun regulation. Quite honestly, never much federal regulation at all until we got later in our history, right? So that is certainly true.
All right, thank you very much. If you would show your appreciation for our panel.
Thank you.
I think we can tell by what the time it is now that we've had a fulsome discussion and we have many questions left in the audience. And so I want to give another big round of applause for all of you.
Thank you.
Thanks.
Invite all of you to check out the Historical Society at nbchs.com. And for those of you here in person, we invite you to come out onto the beautiful terrace and enjoy our reception. Thank you, everybody.
Thank you.